Hello, my name is Bill Edgett, and I'm coming on here tonight to try to bring some awareness to how parental alienation begins. When the process starts early, it usually begins while you're still with your partner or while you're still married, depending on your situation. And one party is usually controlling, and they have isolated you from family and friends. So it's been easier for them to manipulate and control you. And this is a pattern that has been throughout the relationship to the point where it has caused a lot of anger between you and your partner because of how how the relationship is going. And that's where it starts. They are setting things up to get their way, and as long as they get their way, they're happy. But if you put up any resistance at all, then they usually start looking out for other partners or to get away from you. And when they get away from you, they want to take the children. So once that process starts, they can enlist the help of police and child protection. Um, when they do that, depending on what stories they tell, there's two different silver bullets people call the silver bullet. One is the light silver bullet, or let's just say that you hit the kids, or you beat them, or you were neglectful and you didn't look after them, or it's still serious, but it's not really bad, and that's the light silver bullet. And then the real silver bullet is making up making up allegations of sexual abuse against your children, which immediately um, causes a variation in the custody and access schedule and who the children spend time with. Now, what most people don't know is this is a violation of their rights under the National Charter of Rights and Freedoms for Canadians. A person is to be presumed innocent until proven guilty by a judge, jury, or tribunal of their peers. Now, Child Protection has the authority under the Family Services Act in the province of New Brunswick to commence investigations and remove children from a place they deem that is an unfit or unsafe environment for them. The problem is they usually do this based on one person's story. And this is when things get complicated. When one person tells a story, a false story to police or the RCMP or child protection, who in turn contacts the RCMP or the police to investigate allegations of abuse that lead to a civil proceeding, such as a custody and access schedule, see whether or not the party that's alleged to have committed the crime will be allowed to see their child. And in most cases, they have a recognizance brought against them, which they could be arrested for even trying to contact their child. And the police throw this in place immediately against people. And I have a person who has come forward to me, and I've got numerous videos to show how the police didn't ask him any questions. They called him into the station and basically told him that he wasn't allowed to contact his ex, he wasn't allowed to contact his child, and if he went near them, he would be arrested. Handed him a sheet of paper and sent him on his way. So he wasn't allowed to see. He was still married. He was still married, and he had full access to his daughter during the marriage. Now, because these false reports that were made to the police believed them and took action against this individual as if it were true, which is a violation of the Charter of Rights. So they said he couldn't even contact the home of where his child was to communicate with his child or he'd be arrested. So I forwarded that recognizance or the peace bond and the court summons on to the Attorney General from New Brunswick at the time, which was Andrea Anderson Mason. Um, Something must have happened because the police officer who had written this up lifted that order. Now, I had gone through a similar process, and the people that arrested me, they said they weren't able to change the order. The only person that was able to change it would be the detective that was handling the case because I couldn't go to work because relatives of the people who made the false reports to me work at my employer as well. So I was unable to go to work until I got certain restrictions lifted. Um, I was to court and I was found not guilty. Um, Yet all these actions were taken against me. I've got a number of people and a number of files to show this pattern of police failing to conduct proper investigations and failing to write down any of the information provided them by the people that are alleged to have committed crimes. Instead of, if the alleged crimes didn't happen, yet civil or criminal proceedings have taken place, then that is a crime of public mischief. Public mischief is the crime of false report leading to a civil or criminal proceeding. Now, this is happening. Now, instead of the police making new reports from the person these false allegations were made about, they try to hide them in the report of the original person that made the complaints. And by doing that, when people review the reports, they think it's, and I can show you an example because I've got the reports that I've made to the St. John Police Department. And I went in and I've got three different St. John Police report files for the same incident. Um, I believe two of them are fabricated because I'm, I can go over that and that will be part of the documentary to show how these came to be. And they were all different, but it was all about the same issue. Um, I'd love to share more about that, but I do have other people that have come forward to me, and they have got their police report files from the policing agencies they've been dealing with. And when these police agencies or detectives or constables or whoever shows up to deal with these situations, they kind of ignore the person they're investigating and don't put down any of the remarks that they make because it doesn't coincide with the narrative or the story they've already been told. So they disregard everything else and just look for information to corroborate the narrative, false narratives, allegations that they've been told. Now, John Mast is an example of that one. He was accused of molesting his children. He fought for 4 years to try and get his children back in his life. And when it was finally court ordered for him to be able to see his children, his ex wife's father, who had been subjected to her persecutory delusions, and these the delusion was that he had harmed his daughter or his son or both his children. It's I haven't gotten the full details, but he had undergone numerous tests, including a polygraph, um, to determine that the allegations were not true. He had never harmed his children. He was a loving father. He was been being denied access on false allegations. After years of fighting, he finally won the right to have a weekend with his children. He went in good faith to pick them up to a local grocery store where he was met by his former father in law, not his children, just by the former father in law, not his ex wife, not the children, just the former father in law with a gun, who shot and killed him because he also suffered from the delusion the mother had created. And so do the police, and so does the Crown, and so do the judges in these cases. They all work against the person who has allegedly committed a crime which is a violation of their rights, and put sanctions on them so they don't get to see their children without even conducting a proper investigation. For one of the cases I have, not only did the party go to the police station to get a peace bond brought against her former or her still um, partner, but the same day, Section 7 motion was made to the Attorney General to grant that party full custody of the child. So this, for them both to happen and be filed on the same day, this is not normal knowledge of how to deal with the family court system. And they're two different courts. One's criminal court, one's family court. So what is done and what a lot of lawyers are doing and guiding people, because I believe this person had some guidance from a law firm or a lawyer, told the person how to proceed to get the peace bond issued by the police against the other parent, and then make an application for sole custody of the child because the police were investigating him for harassment. It's done every day. Now, when it's proven that there was no harassment and all the allegations were false, there's no repercussions for these parties. That's sending the message that if you want custody of your kid, lie. Create a big enough lie that child protection, the police, or the courts are going to step in and do anything to protect that child and take them away from that parent you made the allegations about. Because right now, that is how it works. I shouldn't say that is how it works. That's how it works if these allegations are made against men. I'm not sure how successful men have been in making false allegations like this about women. Not to say that women aren't alienated, men and women are alienated equally. But when it comes to criminal court getting involved with family court, and then there's supposed to be two separate courts, and one has no bearing on the other. Yet, criminal court and the police and the crown and child protection are all being used as tools, and they're not doing their jobs. If they did their jobs, these cases wouldn't go on for years. They'd be settled quickly, and the party making the false reports would end up in jail for perjury, making false statements and affidavits, false statements to the court, for public mischief, for making the false reports that led to the civil and criminal proceedings, whichever it may be. It's 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 become so common practice that, like I said, I have one case that I'll be highlighting where The report to the police was filed first before the application to the family court. But they were done the same day in that order. So they had some guidance to be able to do that because at that time I still hadn't seen that or thought of that being a possibility. And because usually the process is if you're being harassed or anything by the police, you report it to the police. To report it to the police, then go to across the street to make an application to have the minister step in and give you custody. Well, you're using one to try and influence the other when they're two separate issues. But that's what happens every day, and ooh, people need help. They're getting run over and further abused by the system that is meant to help them and protect them. And what people really lose sight of is the children. The children are affected by this. The courts, according to Dr. Stephen Miller, in high conflict divorces make wrong decisions 95% of the time. That's 95% of the time they're making decisions in favor of the abuser instead of the target parent because they don't recognize the situation. This is what makes these situations last and go on for years until the truth finally comes out. Part of that is no one can understand logically or rationally why a party would behave that way. And that's the point. You're not dealing with a logical or rational person. You're dealing with a person that has a personality disorder or a mental disorder of some kind, which precludes them from having any reasonable communication with their former partner or other parties about the situation because they are driven by a need to control things and they are not willing to compromise on any issue. It has to be what they want and nothing else. And after seeing that for years, the courts recognize that that's the way the person is and they're not going to change. That's why people are there in the first place. They've got to recognize this sooner instead of trying to send them for mediation through therapy. Traditional therapy does not work. Mediation is not going to work. All this is going to do is allow the children to be further abused and damage their growth and development longer, which will take even more time for them to recover. Most likely, if it isn't stopped in time, the child or children will develop borderline or personality or narcissistic personality disorder because that's what they're seeing and that's what they're being subjected to. They're allowing this to happen to children. They could stop it, but this is filling the next generation of courts. This is keeping everyone paid. It's they need to protect the children so this doesn't get passed on from one generation to the next. Because the children will grow up thinking this is normal family behavior. They'll end up doing the same because that's just what they came up with. That's what they were brought up in, and that's what they saw. And they will also have missed developmental stages, such as being able to handle their emotions. They'll develop proper attachment bonds. Um, there's a lot of different things that could happen to the children because of what they're being subjected to and depending on what stage of development they are in. They will usually show signs of manipulation or coercion by the alienating parent. And those are the traits of a narcissistic person that the child will start to imitate because that's what they see. You need to learn to recognize that you're in this kind of pathology relationship uh, that you need to get out of and get help for your kids. Um, if any of these things are happening and you are being called by police, arrested by police, being investigated by child protection, you're going to court and you're not seeing your children because of false allegations, that's a violation of your rights. That's negligence on the part of the investigating bodies to not properly recognize the situation because I've seen the police reports in my case. The police failed to put down any information that I provided them. They only looked for information that corroborated what they were told by my ex. So what I did was I started recording all communications. I started doing all my communications, video, audio recording, or through email, having a copy. So that when I do go to court, what I said and told police doesn't match what's in their police reports, and it looks like I'm the cause of the problem when the real problem is they failed to do their job. They heard a story, they believed it, and they were just trying to prove it, and they just ignored all the evidence and information I gave them. So if you're dealing with police or RCMP, record everything. Record everything because you're going to need that to go to court because they're going to fill out their reports based on what the first narrative that they heard. And that's going to be how they look at you, in this case, throughout. They're going to disregard evidence. They're not going to hear what anyone else has to say if it doesn't match with the narrative they were told at the beginning. They're only looking for something to corroborate that. And that's not investigating. They're being negligent by doing that. You need to record it to protect yourself. You need to be able to have that evidence to fight back if you want to keep your children in your life. Because all the stories and all the reports by everyone will be against you. And you'll have nothing to show for it. No matter what you told the police, they won't put it down. And when you say, well, I told the police officer this, I told the police officer this. Well, here's the report, Mr. Smith. I don't see any of that in his report. Are you sure you told him that, or are you just making this up now? And that's it. That they create a paper trail that makes you look guilty, but it's just a paper trail of fluff they used to violate your civil rights. I know many people are going through this because I've got a number to interview and have interviewed. I've gone through the same process, and that needs to stop. That needs to stop because they're the police, child protection, the courts, the crown, the judges, by failing to make decisions based on the evidence and only out of the fear of a child getting hurt and the narrative that was created without properly investigating to see if the allegations are valid. I lost custody of my children because the judge wanted to err on the side of caution and have the investigation completed before I was allowed to see my children again. And even after the investigation came back, It was cleared by the social worker and the RCMP who investigated. Still didn't return my children to me. There was a trial to be set. We had scheduled that should have taken place just after her making this emergency application on the false report she made to the RCMP. I've already posted that. So, because of these emergency applications, we never had our trial. And after the judge realized he gave the children away under false pretenses and had no valid reason, he returned custody to me and said, "There's no trial. Go away. Be happy you got your kids." So now there's many motions before the court, and he's trying to keep it from going to trial, trying to protect her because I think sees what's going on now, but he, there's multiple issues that need to be dealt with at trial. She still has a contempt order, a contempt charge against me to have me jailed and my vehicle seized for an amount of money that has already been paid. But she still wanted to move forward with it. I've been calling the RCMP to report every violation of our divorce agreement, all the all the contempt charges. It's going to be a big list, and I had big lists before I provided, and they just didn't want to deal with them. The RCMP tried to arrest her. They wanted that document removed from the record. The prosecutor's information sheet the RCMP provided to the Crown to have her arrested for criminal harassment. So they removed that. I think it's quite relevant that they recognized after their investigation that she was using the peace bond that the St. John Police Department put against me as a tool to try and arrest me. And I was arrested by the St. John Police Department for following the directions of an RCMP officer. I was found not guilty because I was following the directions of the RCMP officer and I was following the conditions of our custody and access agreement and the recognizance I was placed on by the St. John Police Department. They hauled my friend in for calling to pick up my children from me to act as a third party, which was a requirement for exchanges of the children. I have a DVD of that interrogation. They hauled my friend in and interrogated him. They arrested me and I had to go to trial. Now, Detective Leslie Drost, I have the email that Constable, I don't know if he was Constable at the time, whatever his rank was, it was Gerald Bigger. Gerald Bigger had sent an email to Detective Leslie Drost of the St. John Police Department. Detective Leslie Drost had put this into his file, and it said that both myself and my friend that was interrogated by the police were following the direction of Gerald Bigger. So at that time, the detective knew I had no criminal intent to break the law. I was following directions from a person of authority. Plus, I was doing everything in compliance with the custody and access order and the recognizance I was placed on by the St. John Police Department. So he still passed this information on to the Crown prosecutor, who was Kelly Winchester. Kelly Winchester interviewed Gerald Bigger October 3rd, one day before the trial. She told Gerald Bigger not to show up to the trial, and he did not. That's obstruction of justice. And that makes her part of a criminal conspiracy because at that point she knew I also had no criminal intent, mens rea, to break the law. In fact, I called and asked the RCMP for direction on how to handle and move forward to get my children. And instead of getting my children, I was arrested, and my friend was hauled into the police station and interrogated. I had to pay thousands of dollars for a lawyer to defend myself. Kelly Winchester became part of criminal conspiracy to find me guilty of allegations she knew I didn't commit at that point. Same with Detective Leslie Drost when he received the email from Constable Corporal Gerald Bigger, whatever rank he was at the time. Well, both those parties knew I didn't commit a crime, yet still moved forward to find me guilty of a criminal charge. That's called criminal conspiracy, and I called the St. John Police Department and provided them evidence of this criminal conspiracy. Chief John Bates at the time, or no, sorry, Bruce E. Connell was the chief after John Bates. I got a letter from Chief Bruce E. Connell stating that he was summarily dismissing the charges of criminal conspiracy against Detective Leslie Drost and Crown Prosecutor Kelly Winchester with the approval of the New Brunswick Police Commission. The New Brunswick Police Commission is supposed to be the independent authority that oversees the municipal police forces in the province of New Brunswick and make sure that they do their job. Now, I don't know how the two of them work together to agree to this because they're two separate agencies. So if the police didn't do their job, it would be my next step would be to make a complaint with the New Brunswick Police Commission. So they took that avenue away from me. So they colluded with another provincial agency to cover up the crimes they committed. By the way, Kelly Winchester is now a provincial court judge. So they're protecting a judge now, not just the Crown prosecutor. I've um I've got many communications recordings, and I am so looking forward to getting these out and in the public so people can see just how corrupt these people are and how they completely disregard the law if they're told a story. And it happens every day. This didn't just happen to me, didn't just happen to the other people I've talked to. It's happening everywhere around the world. And we need to have accountability. When people make false reports that lead to civil or criminal proceedings, that's public mischief. When they perjure themselves in affidavits, that's perjury. When they submit lies, when they lie in their testimony, it's perjury. When they fail to follow a court order, that's a violation of Section 127 of the Criminal Code. When they keep a child in contravention of a court order, that's Section 282 of the Criminal Code. There are measures that can be taken to remedy the situations that happen, but no one is enforcing them. And if they're not enforcing them against one party, it looks like they're protecting them and they're being discriminatory in how they enforce the laws against the different parties. That needs to change. Back in '98, Department of Justice, when they came out with Forsake of the Child videos, that was some of the recommendations they made, is they would have to start, when there was false allegations of abuse or sexual abuse, that they would have to start looking at remedies such as charging people with perjury or public mischief to deter this kind of behavior because it has grown and it will continue to grow because it is effective and it keeps one parent away from their children for years. In the case of John Mast, it was almost 4 years. And because someone is subjected to the mother who was delusional, told lies, she passed on that persecutory delusion to another person. And that other person killed her ex husband who had done nothing except love his children and fight to have them in his life. These people are dangerous. They will enlist the help of everyone, and they have the same story. They tried to do everything right. Everyone's against them. They're just struggling to look after their kids, and you get to pick up on it real easy. It's it's not that easy because a person that suffers from borderline personality disorder and a person that is suffering from PTSD have an 80% overlap in how they act and then in their behaviors. So unless you know how to recognize that 20%, you can misdiagnose a person. Instead of believing that this person suffers from PTSD, they might be borderline personality disorder and they might be the one causing the high conflict in the divorce. And like I said, the courts get it wrong 95% of the time, according to Dr. Stephen Miller. All right, I think I've ran it along for enough tonight. Parental alienation. Got to start documenting right away. Um, you need you need to get the right people in there and get the real story out as quick as possible, because the longer you are kept from your children, the longer it will be. The courts want to maintain the status quo. They don't like doing changes. And in most cases, they don't have to make decisions because not that many divorces go to trial. So they just keep delaying, delaying, and delaying, maintaining the status quo, which is allowing children to be in toxic, abusive situations for longer and longer, which is going to affect their growth and development. Again, yeah, I've gone on long tonight. Quite a long chat. I didn't plan on being this long, but hope somebody learned some information. I'll try to keep them shorter. Um, everyone stay strong. Good luck. And I hope to be able to give you a lot more information and show this process so everyone learns how to do things for themselves and get through this situation faster so you can get the children the help they need. Good luck, everyone. Stay strong. Remember, you're not alone.